Good afternoon, YouTube. Listen, I wanted to follow up on what I said my Valentine's Day conviction, February 14th, 2013. The main issue is when you go on a trial, any trial, federal or state, you have what they call due process. You have a right to be found guilty beyond a reasonable doubt of all the elements of a crime. I was charged with aiding and abetting possession by a firearm by a convicted felon. What that means is when you're attacking aiding and abetting and all these words and statutes, 18 U.S.C. 2 with 18 U.S.C. 922G, there's a mens rea element that have to be proven in all those trials. Now, the Fourth Circuit Court of Appeals nor the Supreme Court has ever really officially stepped in and ruled in aiding and abetting possession of a firearm by a convicted felon. But during the Obama administration, prosecutors was indicting people like this. They was presenting it to the grand jury like that, aiding and abetting possession of a firearm by a convicted felon. They were presented to the judge like that, aiding and abetting. The judge would read it to the jury. Now, during the trial of the evidence, the judge have to direct the jury in their findings of the evidence presented. Now, when you go on aiding and abetting possession of a firearm by a convicted felon, it's like a tongue twister, and it's easy to get confused. The government could present evidence that, there was gun sales done. However, some people don't know if that's legal or illegal. But it never said there was illegal transactions. They just said illegal possession, aiding and abetting. So, in order to be convicted by jury trial beyond a reasonable doubt, the jury must find all the elements. Did the government prove beyond a reasonable doubt that Lionel Cox knew the principal was a felon? The government never presented the evidence. The judge never gave the jury instruction that was proposed several times. Even though it failed to object upon, it was proposed to the judge. The judge never gave the jury instruction. So the jury was allowed to deliberate upon the instructions that the government had to prove that Mr. Cox knew that it was a crime being committed. So what is a crime? Well, evidence that was presented made it look like illegal transactions. So it was easy. Oh yeah, transactions. He wasn't supposed to be doing it in the jury's mind. However, when it goes up to the Court of Appeal, the government, in their arguments, first jumped on, hey, the defendant has waived this argument. This argument should not be heard. So why is the government saying that the defendant waived this argument? Unless the government already knew that the defendant's substantial rights was violated. If you go to oral arguments, September 19th, 2014, Fourth Circuit Court of Appeal, the government came up with their conclusion that defendant waived this issue. When they say the defendant waived, that means counsel waived the issue, because counsel did, the lawyer's words, prosecutor, the government's words, they did not fail to raise it to the court. The court just didn't give it. So the government and the defense both agreeing that the court failed to give this proposed jury instruction, and that they waived it because they didn't object. That right there alone should be grounds for a new trial. A new trial. Because a person's substantial rights was violated. He has a due process right to face a jury, impartial jury, and due process of be convicted beyond a reasonable doubt of every element in the indictment. When the main jury instruction that demands that the government show this evidence, or did they show this evidence, was not addressed to the jury, that's denial of due process of law. Go check it out.